Okay, so we're about to start. Let me just check. Evelyn, can you hear me? Evelyn?
Hi, I'm here. Good morning.
Okay, great. Very clear. So now we can start. Ladies and gentlemen, welcome to Navigating the U.S. Market for Chinese Enterprises. I am Kailan Chen, an LLM candidate at Georgetown Law and also the main organizer of this event. In the past few years, despite the shadow of the China-US trade war, extensive trade and investment activities between the two nations are remained highly active. How to invest in the US continues to be a pressing concern for many Chinese entrepreneurs. Today, we're excited to have our 4 distinguished panelists joining us to share their insights on this issue. We'll be discussing the challenges Chinese companies face when they invest in the US, and also the opportunities and the advantages they have. We'll also discuss the compliance issue and litigation risks that enterprises need to consider in cross-border investment and transactions. Now, I am very honored to introduce our 4 distinguished panelists. Our first panelist today is Professor Don S. Damick. Professor Damick graduated from Harvard Law School. He's the faculty co-director of the Center on Transnational Business and the Law, and the faculty director of the Executive Securities and Financial Regulation LLM program. He joined the faculty of Georgetown University Law Center in 2019, following a career as a partner at Ropes and Graves, an international law firm, and as the vice president and general counsel of the Overseas Private Investment Corporation, now the Development Finance Corporation, the U.S. government's bilateral development finance institution. Our second panelist today is Louis Hong. Louis Hong graduated from Stanford University and the University of Oxford. He's the founding partner of FP Solutions VC, specializing in hardware startup investments globally. He brings a wealth of experience as a former executive at SpaceX, where he worked closely with Elon Musk for 7 years, playing a significant role in the company's growth. With over 15 years of management experience, Louis has extensive expertise in aerospace, new energy, and automation. And Evelyn, can you hear me? Where is Evelyn? Okay, Evelyn Riley graduated from George Washington University Law School. She's the lawyer at Cousin O'Connor. With over 10 years of experience, Evelyn handles commercial and complex disputes in all stages of civil litigation. She represents clients in both state and federal courts throughout the United States in a broad range of matters. Evelyn is also the co-chair of Cousin O'Connor's Asian American Resource Group. She also serves on the board of directors for the Asian Pacific American Bar Association of the Greater Washington, D.C. area, which is APA-BA-DC. And our last panelist today is Jiazheng Guo. He will join us very soon in person. Ivan graduated from George Washington University Law School. He's a lawyer at Morgan Lewis, D.C. He focuses his practice on the telecommunications, media, and technology industry, and advises on a broad array of telecommunications regulatory and statutory issues, national security issues, mergers and acquisition and financing transactions. Currently, Ivan sits on the board of APA-BA-DC and serves as an associate representative of the firm's Asian American Network and is a member of the Washington, D.C. Office Recruiting Committee. With our 4 panelists and all the participants today, I believe we're going to have a very interesting discussion. Now let's welcome our first panelist. Cheers. Yes, sir, I think you should come here to.
Actually, oh, that's fine. I'll get up. I was gonna sort of stay seated, but I know so many of you from class and this is like, I feel like I'm at home. First, it's great to have you in what is not a class setting. And you have lots of opportunities to hear from actually very gifted professionals in this space that will actually tell you a lot more about what's going on than I can tell you because they're doing it every day. And I sort of read about it and think about it. One of the things that you should all be thinking about, you all have lots of great questions and insights, and maybe you want understanding, better understanding, and these are people who can help give you that better understanding. We every day, I think we all wake up and wonder if there's going to be news between the two countries and whether it's going to be good news or bad news or no news and how it will affect the relationship, because we have had a tremendously interesting 20 and 30 years of economic engagement where, China started as a very undeveloped country, at least economically compared to its peers, and in the last 30 years has become either the first or the second, depending on what metric you're using, economy in the entire world. So a very, very huge and important country, obviously with lots and lots of international expansion. The US engages with China over a whole series of issues, and economic and financial being simply one of the areas. And of course, the whole military, national security issues have tended to, take up a lot of the oxygen, as they say, over the last, probably 5 years, 10 years, but, sort of going through today. So it's a very, very interesting, difficult, challenging time that we sort of are in right now. Having said that, I think that what both nations talk about is finding ways to coexist, to be able to work together in as much harmony as we can find. And one of them actually has historically been economically. And you look at China, it's the major exporter of products into the world trade issues. You have the United States, which actually is probably the major importer of goods from China. So there's a very, very, close economic relationship between the two countries. And of course, we've seen lots of foreign direct investment into China. And as China has accumulated more capital, we've actually seen then Chinese foreign direct investment into other countries, including the United States. And so what we're talking about today is basically, and I'm going to say, business into the United States, right? How do Chinese businesses come to the United States and how do they in some ways succeed and penetrate the market? I actually, for those of you who've been in my class, you see I use lots of PowerPoints. I actually have this cover slide and only one other slide today, because what I'm going to be talking about are choices, right? Choices as in decisions that need to be made or thought about by, and I'm going to say the Chinese investor or business person. I mean, it could be any business person, we happen to be talking about, sort of China. And by the way, I'm delighted to be here. Last week at this time, we had a Brazil, doing business in Brazil program, and there was a lot of activity on that. And so I'm glad to have, sort of Chinese engagement and how we do greater business. Okay, let's see. You'll turn the slide for me. Okay, this is my only slide, and I'll sort of talk through it and try to give you some insight. I say Chinese investor, I mean business person, and I'm thinking actually, one way to do business is to sell product, right? And you don't need to actually be located in a country to sell product into a country. And that's how most of the Chinese, sort of goods come to the United States, and they're bought by, sort of entities in the United States, but supplied by China. When in my international business transactions class, we talk about non-establishment forms of doing business, right? And that then includes sales transactions. Services can be provided from wherever you have a computer, right? And services are provided. You have distributors and agents, right? Different sorts of relationships. But then you have foreign direct investment, which I talk about as an establishment form of doing business. You actually set up a company, and you set up a company, I'd say most often, or at least this is how I typically see it, in the country where you're seeking to do business. And so, a Chinese entity would set up a U.S. entity, and you've got choices then of U.S. entities. The choice of entities that we talk about mostly in the United States are corporations or limited liability companies, because you don't really think of partnerships for doing business, or even limited partnerships, although they exist. But those are the two basic forms that people would look at. As I was sort of mentioning to the side, there have been over the years a number, significant number of Chinese companies that have raised money in the United States. They've gotten their financing from the United States investors, and they've done it by registering securities with the Securities Exchange Commission in the United States. And when you look at those companies, you actually see that very few of them are US companies. Now, actually, most of them aren't even Chinese companies, even though these are Chinese businesses. They tend to be a lot of Cayman Islands or British Virgin Island entities that are, like, for some reason, the country of choice to organize a lot of these businesses. Now, why might that be? And actually, one of the reasons is that you're now beginning to have these countries, Cayman Islands and British Virgin Islands, that have been thought of for a long time as tax havens. You don't pay many taxes, so it's good. Another thing they both have in common is that they're actually like part of the British Commonwealth, right? And so they have like English law, and there's sort of a great sense in the world that English law and the legal system and respect for the law is an important attribute that people look for in governance. And so Chinese, sort of investors will look there. They also have the benefit, I think, of allowing like the companies to have a lot more flexibility. And one of the criticisms that people have of the United States, like Delaware law now, and we saw it with Elon Musk, is that, the shareholders have rights in Delaware. That's awful. Because that then means that like the people who are running the company and maybe the key individual, Elon Musk, he can be constrained in some fashion by the courts. And nobody likes that, or I say nobody likes it. Shareholders may like it a lot. But sort of the manager, the key person doesn't like it so much. Choice of investment entity. So what would it be, right? And probably a corporation or an LLC, or however those might be construed in whatever country you end up in. The choice of jurisdiction. I mean, I thought everyone would go to Delaware. And I actually, one of the reasons I get out and go to places is I was in Orlando, Florida last week. And believe it or not, I wasn't at Disney World. I actually went there and I was at a conference. I was at a conference of the section of the business law section of the American Bar Association. And it's a group of actually top practitioners and people in businesses too. I mean, sort of inside counsel that meet together and sort of share their experiences. And actually they have a terrific committee. They are called the Mergers and Acquisitions Committee. And it brings actually in not just people from the United States, and there's lots of M&A here, but people from all around the world, because M&A is sort of a worldwide phenomena right now. And there was someone who was presenting, and he was talking about a paper that he'd written where he'd done a deep dive actually into Chinese investors and what type of entity they choose. And he actually said, we all thought like Delaware. No, they're actually, a lot of them choose British Virgin Islands or the Cayman Islands. And I learned something because there are lots of different avenues. You don't have to be a US company to do business in the United States. Right? One of the attributes, right? One of the ways that you could do it, maybe the openness of the United States. And this is a lot different actually than the way that other countries organize themselves. And where you do need to, sort of register locally and be a local entity in order to have access to the local market. So, US on one side, there are other countries on another side. What do people would think about doing business here? And, when you set up a company and as you're operating a company, it needs money. And so you've got a choice again, a choice of equity or debt. And we all know equity is sort of the owners of the company who get a share of the profits. And a debt is like the bankers, right? Well, although what you actually see is that there are people who may own a company that put some amount in the form of equity and the other amount in the form of debt. And actually, if you look at like private equity companies who are, who invest across the world, they'll maybe make a big investment, but some of it will be equity and the rest of it will be debt. Now, why would they do that? And it has to do with the fact that there is an optimal equity position. When you look at the financial sort of metrics, and what companies, individuals seek to do is to find that precise amount of equity that you have to put in, and then you put the rest in debt. And actually debt enables people to get interest payments, for example, on debt that they don't get on equity. And maybe there are tax advantages. One of the items that I think is highly relevant for all investors, and this would be for the Chinese investors very much, is what are the taxes that they're going to have to pay? Because everything that goes to the government doesn't come to them and their shareholders to grow the business or to take out as dividends. Lots of people do business by contracts, right? You have contractual arrangements. And you can have joint ventures by contracts, not by a separate entity, but by contracts, and marketing agreements and licensing agreements and manufacturing agreements and sole source, arrangements. Yeah, the list in some ways is endless. And Chinese businesses can engage with US businesses through lots of different contractual arrangements. And one of the choices, this is a classic legal choice, is what law do you choose? Do you choose the law of, now remember, there's no law of the United States, right? This is one of the things, hopefully, you've all sort of learned over the last year. There's no law of the United States. Well, I shouldn't quite, yeah, there are some laws, right? There are some federal laws, but in the commercial area, it is the laws of states. And so do you pick the law of New York, Delaware, California, the list of, 50 states, lots of possible laws. Or do you seek to pick the law of China? The Chinese party may want the law of China, and the US party may want the law of New York, or wherever they resolve it. And maybe if you're Walmart, with huge power, you get to pick the law of Arkansas, where they're located, which, again, in the United States, at least commercially, we have the Uniform Commercial Code, which actually is part of law unification in the United States, where you have basically the same law that 50 states have adopted. So that while there's no federal law, no national law, it's sort of 50 state laws that look the same. Although sometimes if you, sort of a lawyer and you're careful, you actually do need to look at the state law, because occasionally it's a little different. And if it's a little different and you didn't look at it, that's a malpractice claim confronting you. So of course you care about that. Choice of forum for dispute resolution. Whenever there's business, investment, you all hope that it's harmonious, that we all make a lot of money. And hopefully most of the time it is, but we all know that there are lots of times when it's not. And there are disputes, and there are disputes that we seek to negotiate. And then disputes that we can't negotiate. Of course, it's because the other party's unreasonable, and we're right. And then it's got to be resolved. And how are you going to resolve it? So you have a choice of type of resolution mechanisms. And do you resort to the courts in whatever jurisdiction? Do you resort to international arbitration? And certainly between businesses of different countries, it is by far the most common to use international arbitration, international commercial arbitration. And there are lots of reasons why that I think many of you have sort of thought about. One is supposed to be costs, maybe. One is confidentiality. Lots of businesses actually don't like their disputes known out there. Maybe they're embarrassed by something that they did, or maybe actually there's sensitive business information that might get out, and that doesn't happen in arbitration. So I think and then seat of arbitration is important, right? The seat of arbitration is where you say in your arbitration agreement, you're going to hold the arbitration, because wherever that seat is, right, that jurisdiction, the courts of that jurisdiction have power to, in some ways, oversee the arbitration. If the arbitrator's biased, maybe you can go to the court and get them removed. If the arbitrators were told that they could only look at this and they looked at this, maybe the courts can say, no, that's not permissible, and they annul in some fashion. So lots of issues on that. Now, as you can see, good morning.
Morning, Sam.
How are you? Nope, we understand. See, this is a gentleman, when he talks, you're gonna hear, he's late because he was working. He's got deals he's working on and issues and the like. It's very exciting. And, you know, there is a lot of activity. So when we hear about all of these types of regulations, you know, things are getting more difficult. Yes, maybe they are, but there are lots of people that still see opportunities and are attempting to, you know, sort of move forward in the, you know, changing circumstances. And I think with that, I'm going to end and turn it over to, I think, Louis, you go next, right? Yeah, you go next. You know, Helen was great. She says, well, maybe we'll have the professor first because he can bore people. And then we'll have sort of exciting people here who will tell us what we really want to know. So, Louis, it's all yours.
Yeah. Right. Professor, that's a tough, act to follow, and that kind of simplicity and that directness. So I'll try to keep my presentations brief and to the point. Okay, I do have a few slides to go through. I thought I was supposed to put together a series of slides. But anyways, I'm grateful to be here. Thank you for the invitations and glad to be in our nation's capital. And obviously here in Georgetown and, and sharing and interacting with all of you. As introduced, I am a VC kind of by professions, and it is my job to kind of check out kind of the latest and greatest and most exciting. So today I'd love to kind of share a few of those observations kind of with all of you, and hopefully that will inspire and promote kind of and provide some takeaways, I guess, from today's. Now, I'm not really used kind of to kind of speaking and presenting kind of the monologue. So, and I love for people's engagement. So throughout my presentations, if there are any questions or feedback, feel free to just jump right in and chime in. I love an interactive kind of sharing rather than kind of a presentation. So. Okay. How do I go to the next page?
Where's the clicker?
Oh, is it there? Okay, great, perfect. All right, again, just a super quick introductions. Louis Hong, graduated from Stanford with a mechanical engineering degree way back in the days. And then subsequently, I also went to Oxford, to the dark side, got my MBA. Spent the last almost 20 years in automations and aerospace. Joined SpaceX back in 2012. And subsequently spent the following 7 years with Elon to build up that rocket factory that many people have heard of today. I left in 2019 to join another battery startups, building large scale kind of batteries, for commercials and EV vehicles. Luckily, we rode the EV wave perfectly, and we made that company. I took the company public via a SPAC, at the end of 2020. While I was there, I met my current partner, who came from Tesla. And he was brought in by Elon to turn around the whole Model 3 production hell. And subsequently, he led the deployment of Giga Shanghai factories and also the new 4680 cells. So the two of us came from two of Elon's ecosystems. We have a lot of obviously time and resources into these two ecosystems. And we also see a vast opportunities ahead for all the hard tech companies kind of for the coming decades. So we decided to leave together in 2022, and establish FP Solutions, and in which we're new VCs going out there with the goal of looking and hunting all the early stage hard tech companies. So we tell people that we are a team started by ex SpaceX and Tesla people, and we're aiming to find the next SpaceX and Tesla. I think today most people have heard of Elon, okay? And I think that's a surprise. You're thinking like, yeah, a few years ago, still a lot of people don't know Elon Musk. When when my wife and I first started, dating, back in 2019. Believe it or not, some of her friends doesn't know who Elon or SpaceX is, even back in 2019. But I think it would be good to kind of give everyone kind of a quick oversight of SpaceX kind of progress over the past years. I think most people have heard of the company, but do not understand kind of how far the company has gone, or how influential it is in establishing kind of this new sector in space. Back I mentioned I joined in 2012, and that's exactly kind of a decade after SpaceX had started. So SpaceX was started back in 2002, and then back then started by the whole group of passionate and brilliant individuals that have no clue how to build a rocket. Elon admitted that themselves. Fast forward 2012, they were able to successfully launch the Falcon 9, which is today the most reliable rocket kind of platforms ever established. They were able to also gain as a result of that the first NASA contracts, and then started kind of the ISS refill kind of missions, and that subsequently kind of carried SpaceX to today. Just for reference, right, and launch back in 2012. Okay, SpaceX launched once, okay, and that was a big deal, okay, for the entire company. I remember that first launch, when we all gathered in front of mission controls and the excitement, like making sure that, once you see the rocket successfully launch and then everyone, sort of took a breather, oh, thank goodness, my part didn't fail, kind of during that launch. And in that same year, the entire world launches 34 times. Okay, so 1 out of 34. For fast forward to 2022, a decade later, in that same year, the world launched 93 times, of which SpaceX, was responsible for 68 times of that. Last year, 2023, SpaceX launched 98 times. And this year, SpaceX will push for 150. Okay, now, in addition to kind of the quantity alone, I think the most important number is this. Okay, SpaceX was able to do all these launch with a 97% reuse rate kind of back in 2022. And that is a significant driver, for allowing kind of all the various space companies to use Falcon 9 as a platform to develop all sorts of applications kind of in space. In addition, the SpaceX also successfully kind of developed Dragon, which is the first spacecraft, to bring, good American astronauts, back into space and back, and also, kicked off kind of the next phase of the SpaceX trilogies, in which, we started kind of the Starlink constellations, and most excitingly, Starships. Okay, with the once they made it to orbit, and hopefully, knock on wood, that will be in the coming months. Starship will be the most powerful rocket ever in human history. Not just simply in lift capability, but in terms of volume, and most importantly, in cost. Okay, so with SpaceX's Falcon 9, SpaceX was successfully to reduce launch costs from an average of $20,000 per kilogram down to about $6K. Okay, or even down to $3K, kind of with reuse. They were able to have that price kind of a negotiation power. Now with with Starship, it promises to push this cost all the way down to $100 per kilogram or potentially lower, with, long-term reuse. Now, when something, that drops from $20,000 all the way down to below 100, a bunch of the space infra that were once kind of deemed impossible or kind of or out there, now it's actually a reality. And that's kind of in our thesis, that's our first kind of, and I would say our most excited kind of thesis, kind of looking in the hard tech trends for the coming decades. We're looking to, potentials of trillions of dollars of new space infra opportunities. Now, I would like to kind of share this with everyone. This is SpaceX's newest product, okay, this backpack. Anybody want to venture what this product is for? Take a guess. By SpaceX. Starlink. You're great. You know, I've heard, okay, rocket launchers, I've heard autonomous ships, I have heard, a autonomous tent, but I have not heard of Starlink, but yes.
They're
this-
selling that in Costco now.
They're selling that in Costco, this backpack, right? Okay, now, there you go. You can get, what does this do? Well, this is Elon's promise to the world, right? You can essentially have access to high-speed internet anywhere on the planet as long as you can see the sky. You bring this backpack out in the remoteness, point it to the sky, and you can have high-speed internet access for whatever you like to do. Now, this is a newest employee perk, kind of at SpaceX. Everyone that goes on vacation these days, the company will happily, give you one, for your vacation, so you can have internet access wherever you are. Okay, but no one wants this perk, because people understand, Elon, does not give you free backpacks so you can look at, Netflix, right? If you can get online, they can get you on, back on the back to work. So nobody wants this new perk. Okay, but Starlink communications, or essentially Star Communications, is, we believe, the biggest opportunity kind of for the coming decade. And this inflection point is just right around us, right? Now people are wondering, okay, why bother in space, right? We have plenty of, look at the advancement of our cell network all around us. We're making tremendous progress. Look at the speed of downloads, wide space, right? In the vacuum of space, data actually travels 2 times faster than any most advanced kind of fiber optic cable here back here on Earth. Okay, that's just in the vacuum, in the natural environment of space. Okay, so the only reasons why that infrastructure is not dominant, and we have, the Earth-bound, the cell towers that we have today, is because obviously launch was too prohibitive before. But once that becomes feasible, the new kind of a low Earth orbit infra, kind of the telecommunications will be the dominant form. And then, with cell tower kind of supporting it kind of going forward. And we see these transitions in kind of infra as one of the biggest opportunity, coming around the corner. Now, telecommunication is not, constellation is not the only kind of interesting kind of thesis here. In addition, I'm pretty sure everyone's more than familiar with GPS. I mean, we use it every single day, right? Now, our current GPS systems, as precise and as great as that technology is, for civilian use, it's about a 1 meter kind of gap, in terms of accuracy. Now, for autonomous driving, for drones, for all of these futuristic kind of initiatives that we want to kind of push the world towards, obviously that's not sufficient. Okay, now with the new low Earth orbit constellations, we can push these precisions down to less than 10 centimeters. Okay, and then that will propel a whole new world, including AR, kind of the, I don't know how many people actually bought that Apple Pro, Vision Pro, but that's just the start. Let's see kind of what the more advanced kind of GPS signal where that can take us. In addition, with satellite stuff, we can also build things like this. In the new low Earth orbit, a brand new infra boom. So this is fast. Okay, it's a new startup that's kind of in Los Angeles that's working with SpaceX to develop kind of the first civilian kind of space stations in space. Okay, again, why? Why do we want to kind of create a space up in a space up in space? Mind the pun, right? In this new area, for the first time in human history, and people can now mess with the third dimensions kind of in our environment, right? We can control temperature, we can control pressures, everybody knows that in the environment, but for the first time, now we can control gravity. Okay, this is you can actually control the degree of gravity you want in a particular space. Now this opens up a whole new world, for whether you want it for living or for research and development or for manufacturing. There are some products, that can be made kind of in the 0G or less G gravity that just simply cannot be done on Earth. Okay, and I think that opens up a whole new kind of areas for imaginations and developments. One area that people are actively kind of thinking about, right? It's in the area of chips. Most people are, okay, well, how can we get, 1 nanometer, 2 nanometer, okay? But, when you apply first principle thinking, maybe the most efficient chips is not in like a chip at all, okay? Maybe, the most efficient way to organize these electricals, it's in the sphere shapes. Now, you cannot build a sphere chip, here on Earth, right? But in the zero-G environment, okay, that's worth a try. I think we have a better shot at that in the zero-G. Because an example kind of the low Earth orbits kind of infra and the possibility that's coming around the corner. All right, now we live in a very exciting times and very dynamic times. It's not only up in space, but thankfully also down here, back here on Earth, and in America as well. And we call this second kind of vertical is kind of the 3 Rs. Okay, when in a more dynamic world, essentially 3 things becoming more important: reshored, resiliencies, and redundancies, kind of in supply chains. Now, I'm sure everyone has heard of the CHIPS Act, the Inflation Reduction Act, for supports of chips and green technologies, kind of reshoring kind of back here in the US. What we're seeing more and more are new startups that are focusing on the new advanced technologies that allows for autonomous, low volume, but high variability kind of productions here in America. And that's, in the examples of mass, 3D printings, or, autonomous, factories that, takes your aerospace harnesses, or even our portfolio company, Fiber, which is a material platforms that takes upcycles various waste streams into a new advanced composite wood materials, disrupting kind of local lumber industries. So it's the theme here, it's, made in America, for America, sourced from America. And I think this is a new trend and a startup that's coming up and coming, and it's a very exciting trends to follow. Now, I'm sure everyone has heard of AI and all the fun AI. I'm sure like people are probably tired of hearing AI, by now. Okay, it's funny that when we go to Silicon Valley a lot, obviously for my jobs, and in Silicon Valley, AI is kind of everything, right? In a single month alone, you can hear about there are probably like 84 events, kind of around AI and all the various possibilities. But when you leave Silicon Valley, the rest of America, I think, has a much more, I would say, realistic view of AI. But no matter which way you took, kind of, I think AI is a long-term trend. It is a thing, and then I think it's whether it's in increasing the efficiencies of our current models, or leveraging new models, simulation model to develop, capabilities that we haven't even heard of. I think these are all things that we look forward to, kind of in AI. Now, one area that people have not talked very much of is actually, we just like space where there's a new infra kind of a boom. There is a whole new categories of hardware and infra that should design for AI, and that's just kind of right around the corner. I'm sure everyone have heard a lot about humanoid robots, taking over everything, but I think that's just, kind of the tip of the icebergs. I think we're witnessing that kind of transitions in hard tech, whether it's in the form of autonomous driving, from Zoox, right? A completely, from the ground up autonomous vehicle designed specifically for autonomous drivings, or in the top right corner, this is actually a new kind of wheelchairs, for the coming AI kind of and the generations. This is our portfolio company, and their goal, their Berkeley team that's aiming to kind of facilitate the future of mobility, specifically for the elderly and the disabled, right? So they saw that there's a lot of AI capabilities, for whether or not it's helping you opening a door or completing simple tasks kind of in daily life, but it's not a hardware kind of almost platform to kind of realize that. So they went out there and designed almost what they call the iPhone for the new wheelchairs, and now work with kind of the various applications, for developing various new capabilities, for the elderly and the disabled. Now, as Jensen famously said, right, all AI kind of leads to kind of a energy that has final form, right? And as our world continues to electrify, and as whether that's in the form of, and then you also have Web3 kind of crashing the parties, and now AI, we're seeing kind of at least a 40% increase in our demand on our grid, kind of for the coming decades. And this presents also another tremendous opportunity, which is in the energy infra that we're waiting to upgrade. Now, whether that's in the form of grid enhancements, I'm not sure how familiar people here are with the United States grids kind of situations. But there's like the East Coast grid and there's West Coast grid and there's Texas. Okay, and then I'm sure a lot of people have read about kind of issues with Texas grid over the past 12 months. And that presents a tremendous opportunity as well, for solutions that can provide immediate I would say way to kind of ease our grids, so to speak. And whether that's in the form of smart controls or kind of store better battery storage in a narrow area for virtual power grids, or just better energy storage solutions kind of altogether. I think this is the number kind of a takeaway. Currently, the cost of coal electricity is about 3.2 cents, kind of per kilowatt hour. Right now in the US, when you factor in green plus storage, we're averaging about $2. So there's a tremendous gap still kind of between renewables and kind of so-called kind of dirty energies, right? And this is a tremendous space, for entrepreneurs and investors alike. China already has a bunch of solutions kind of for this gap. And I think going forward, I think the collaborations, I think in cross-border, I think this is going to be a huge area, I think, and huge opportunity kind of for all entrepreneurs. Now we're also in an age where in addition to kind of the renewables and the story that you kind of heard of grid updates, we are also there's a new kind of push for nuclear. Now the U.S. grid is composed of 60% so-called coal and natural gas energies, 20% renewable, and 20% kind of nuclear. Now the U.S. has not touched nuclear for the longest time. The two newest like nuclear facilities in the US was built back in the 90s. Okay, so US has not touched nuclear for all of, but I think going forward, there's a renewed kind of initiatives to use nuclear as a replacement, a better alternative, for coal to natural gas and stable energies. So, and this is the area that we're actively following. And within it, obviously new generations of nuclear power plants, as well as these super kind of micro nuclear power plants, I think it's a thing of interest. This one in particular is developed by an ex-SpaceX team. It was actually Mars kind of mission team, an engineer whose whole mission was to kind of figure out how we're going to solve the energy issues kind of back on Mars. Now, rather than waiting for Mars, he decided, well, heck, here on Earth, we can use the solutions right away. And he went out there and started this new portable kind of nuclear energies company called Radiant, which promises to deliver this container-sized nuclear reactors to provide unlimited, uninterrupted energies for a small community of 1,000 homes, for about a span of 5 years. And then at the end of 5 years, you just simply replace the cords, and then voila, you can kind of reuse this facility again. So it's a new power as a service kind of model that promises to obviously to be a new addition to kind of the grid. So these are the kind of the biggest trends that we've seen kind of recently. And I think one thing that's not very apparent kind of through this presentation is that a lot of these companies that I've listed in the examples, they have one thing in common, which is they're all started by people from SpaceX and from Tesla, which we kind of nicknamed, kind of the new Elon Mafia. So people have, wonder, how big is this group? So as of early last year, there's about 157 companies, cumulatively generated 190 billion kind of in fundraisings, kind of in the various to develop, projects in various areas, as in 3D printed rockets for relativity. Synteco is a biotechnology company. Hermes is the next generation supersonic company. Reliable Robotics is trying to figure out how do you give you autonomous flying. Rebellions, this is AI specific chips, etc. We think that this is a very, very interesting ecosystems with tremendous kind of build and development capability. But as good as Elon Mafia is, I think when you talk about hard tech, you cannot avoid, supply chain. Now, when you talk about supply chain, it's hard to avoid China. And I see that, again, going back to kind of what's the opportunities kind of for Chinese entrepreneurs and investors alike. I think in the new age of hard tech, I think the collaborations, kind of between the both sides to push these initiatives, I think it's something that will truly, I think, accelerate kind of these various areas. And this is the type of future that we're hoping to facilitate and also to see. So anyway, thank you for hearing my rambling now. Thank you.
Thanks, Louis, for sharing with us.
Do you want to take questions now or wait till the end? I mean, how do you want to do this?
Yeah, we have a question section, like after all your presentations. Yeah, but if you have question now, you can ask, you can just raise your hands.
I have a question. So as for Louis, you mentioned hard technology, hard tech. What's the definition of hard tech? Is that tangible, physical, advanced technology? So that's not software related. That's how you define hard tech?
Well, nothing these days is purely like hard, like as in, just hard tech, hard, like as in physical. Everything is a merge between, hardware and software. And so in another word, we don't really look at kind of theses without a physical component. We don't invest in SaaS company. We don't invest in, fintech companies. We invest something that has a physical presence, kind of in the real world.
Okay, thank you.
Thank you for that clarification. Yes, because we struggle to find an ideal. Some people call it deep tech, some people call it hard tech, some people call it hardware. We believe probably hard tech summarizes better than anything else.
Well, and you mentioned at the end, supply chain, which sounds great. What impediments do you see to that?
Yes, I think Professor, I think we're in a very interesting time, right? I think there's this rising kind of anticipations of China kind of starting a second round of dumping, so to speak, of kind of excess kind of manufacturing capability. I think that's a very realistic kind of worry, but at the same time, I think, developing hard tech is hard as is, right? And then so if there are any kind of shortcuts or anything that's that the entrepreneurs can leverage to alleviate that piece of the puzzle, and I think that will be crucial, kind of to continue to push these different sectors forward. I think the China's supply chain capability, I think is very, very mature. It is, we took, a few trips kind of over there back in China, kind of over the past few years, right? And I think China has not only has that the most complete, I would say, kind of value chain when it comes to supplying kind of these various components, for whether it be sensors or hard techs. But at the same time, I think China also has a large reserve engineering talents, that can almost add as additional boost, to not only serve as in just simple OEMs, with these these companies, but also kind of as additional boost on product refinements, also in some degree, some enhancements as well.
Now, you had talked about in the chart you had of the Elon Mafia. I like that, by the way. It's a nice term. Those are all US companies,
Correct.
basically?
Correct.
Now, is there an equivalent ecosystem in China? So when you think about this, how much do you also look at the Chinese market to see if they're going to be future competitors or whether they're going to get ahead of you? And what observations would you have on that?
No, absolutely. And I think in China, it's similar to Elon Mafia. They have the Ali Mafia, they have the Tencent Mafia, they have the DJI Mafia now these days. And I think one thing that's apparent kind of about China is that China is very good at not only, I would say, generating kind of a new text, kind of in these new sectors, but also iterating. I think China, the ecosystem is super competitive, and the rate of iteration is super fast. right? So you're absolutely right. Like as a US company that's doing kind of these projects, I think hard tech, is your temporary moat. I don't think you can count on that as a long-term moat. And I think more importantly, market access, and kind of the other aspects kind of associated with your business model. I think it's an even more important kind of area that we scrutinize, kind of when we look at new companies. Right. I think one common kind of I think things that entrepreneurs like to talk about, when you're talking with startup founders is that, oh, well, look, we have this unique IP and only we can do it. Right. I mean, this is our true moat. And whenever you hear that, I simply say, well, yeah, I like to believe that. Okay, but I believe at most you have like about a year ahead, a year runway ahead. That's it. Right. So how does your business, survive beyond just your immediate product, your immediate IP?
Any questions from our participants?
I actually have a very interesting question. Like, as you have talked about AI, like it is might be the future of our society. They can do a lot of things for us. So do you have concern like they might be out of control by human?
Because we are really afraid that as lawyers, we are
Yep.
afraid that we will be replaced by AI. Yeah.
The ChatGPT 4 is it very powerful?
I don't think AI will ever replace any humans. I think AI is a technology, just like any other tools. But I think people with more advanced tools will replace people that with less tools. I believe that trend. Okay, so I don't think AI is something that will influence or change society in a vacuum. Because I think at the end of the day, it is still, another powerful tools that boosts the human that's driving these applications. So I think, there are probably boring things that you guys all wish that, you don't have to do. And I think those are probably the lower hanging fruits that I think automations and AIs can replace first. But as far as AI replacing lawyers and, representing people, in court, I think we honestly are a little bit ways away from that.
Yeah, thank you.
In my sense, and I must say, I don't understand artificial intelligence sets of issues, although we're living with it all, and we have been for 10 years. I mean, it's not sort of so new. But I liked your term technology. I mean, in some ways, what I think you should all strive for is to better understand AI and find out and determine how you can better use it and the various sorts of tools that it has to do your work. And in some ways, being able to manipulate. Well, I'll give you an example. Back when I started, before any of you were born, when I started law, they actually they were developing, it was still in its like beta model, the first text searches of cases, right? I mean, you had all of these cases that people had decided for 100 years, and they were very hard to access. And so they came up with these systems where they, put them in the database, and you began to be able to put in words, right? And you could get cases that came out. And part of what you learned is, if you asked better search terms, you got better results, right? And you could find maybe more precisely and more quickly what you needed than you used to be able to do it, right? Now, did it put some people out of business? It probably did, who went through all of the volumes and very carefully went through things. And I think of AI in some ways like that. It's going to improve your ability to do a lot of things that actually are more tedious and complicated to do now.
I think we can address more questions in the Q&A section. Yeah, so that we can have our lunch sooner. Okay, Evelyn, can you hear me?
Yes, I can hear you.
Okay, we can hear you too. So you can start now.
Great. Hey, good morning, everybody. It is an honor to be here And I'm humbled to speak after these two distinguished panelists. I hope that I can follow well of what they've discussed. I'm sorry I can't be there today in person, but hopefully we'll stay in touch. If you have questions for me, obviously you can contact Kailan. And thank you, Kailan, for inviting me today. So just to begin with, I want to do a very brief introduction of myself. I know Kailan's done the work for me, but just to remind me and as it relates to my later topics, I came to the US after graduation from Beijing Foreign Studies University Law School in 2010. I obtained my LM from GW Law School. I had a focus in IP. And after that, I interned for the former Chief Judge Radar at the Federal Circuit. And then I passed the New York bar. I was licensed in 2013, and I started my career here in 2013 as soon as I got my bar. My first job was at a boutique DC firm called Cuneo, Gilbert, and LaDuca LLP. I had a focus on class action antitrust litigation. On the plaintiff side, I've had wonderful experience with that firm. I learned everything about US antitrust law and plaintiff side class action litigation, and just generally everything related to civil litigation, motion practice, deposition, third-party party discovery, working with economists, experts, figuring out damage theories, class certification, etc. And about 2 years ago, I switched side to a defense firm, Cozen O'Connor. This is my current firm. It is a full-service firm with award-winning practices in litigation, business law, and government relations. And my practice in Cozen covers a very broad range of areas, including, for example, privacy, product liability, contract disputes, consumer protection, trade secrets, employment issues, premises liability, and high exposure matters, et cetera, et cetera. So what I do mainly in the US is litigation. So today we're talking about entering into the US markets. I want to talk about generally, this is a broad topic, but we can touch upon the general topic of general risks for businesses in litigation in the US and what my opinions are about how we, generally handle those risks. So when entering into the US legal system, you must realize it is very complex and it is very different from the Chinese legal system. It is a common law system. It has federal and state systems, and there are different levels of court involved in these systems: trial level, appellate level, and the highest level of court or federal. Of state court or federal courts. And when we talk about courts, obviously we think about jurisdictional issues that would include personal jurisdiction, subject matter jurisdiction. And then when trying to figure out where to file cases, you think about venue, or where you sue people, you think about your venue. And then once you are in the suit, obviously there are a lot of pretrial motion practice involved, and then you will do pretrial discovery. And once discovery is closed, you have to go to, trial or bench trial, jury trial. And in that process, you may think about mediation, settlement, arbitration, alternative dispute resolution, right? So oftentimes our Chinese-based clients do not fully appreciate the complexity of this legal systems and what it entails, especially in terms of litigation risks. They may not realize that, any steps that they take in conducting, forming, doing businesses in the US may impact the result of the litigation, and then consequently, their business operation day to day. For example, there's something called mandatory arbitration clause. I'll give you a case that I handled a while ago. So we had a client who came to us 2 days after a complaint is being filed against him, and he was in a super hurry. And he said, "Please take me as a client. I don't have time to, to sort out who's out there who can take my case. I know you. Please take it, because you know what? They filed a TRO against me. I have to go to this hearing in 3 days, and I'm not represented by counsel, and I'm afraid." So, this kind of situation, you really want to look carefully in your contract. So we took his case, we investigated the contract, and we found this mandatory arbitration clause. And it is obviously agreed upon and signed by both parties. And we said, that's interesting, because the plaintiff took the case to court and there's this mandatory arbitration clause, and they should have, gone through arbitration before they brought this case to court. So we found that misstep of the other side, and we were able to move to compel arbitration to stay discovery and alternatively dismiss the case. The court didn't listen to us, so the motion was denied. But immediately after that, we were able to appeal that order under the FAA, Federal Arbitration Act, and we appealed it to 2 circuit courts. Because there was a jurisdiction ambiguity, which court has jurisdiction over the issue. So by doing all these, we avoided discovery, which was going to be extremely burdensome and costly for our client. And not to mention that we knew there's going to be stuff that's going to be discovered through this process that's going to be negatively impacting the consequence of the case. So, and speaking of arbitration clause, there's a strategy that many businesses like to use in drafting their employment contract, which is to put in an arbitration clause with a class action waiver. The inclusion of that arbitration clause with a class action waiver can turn a dispute involving multi-million-dollar exposure of claims into sometimes a simple bilateral dispute, which is great for businesses. So this is just to tell you, after stepping into this complex legal system in the US, oftentimes you will face litigation, and there are things that you didn't think of before you conducting business, but you should. Before you form your business, before you choose where you conduct your business, before or after being sued, there are a lot of things that can change the result of the litigation, and a lot of risks involved in that. And thinking of that, many clients will come back to us and say, okay, I'm being sued, or I'm about to be sued. Can you tell me what happens next? And there's always this joke whenever you ask a lawyer a question, the answer will be, it depends. And I wish the Chinese clients understand that is not simply a joke, that reflects how difficult it is, for a lawyer to answer a question like that, what will happen next? I really don't know. It really depends. So they want definitive answers. There's not going to be a definitive answer to any of these questions. They're not simple questions. In a adversarial system like here, you never know, for example, what your opponent's going to do, and then you have to respond once they make a move, and you have to change your strategy constantly based on what your opponent do, what you see in discovery. Sometimes good stuff gets discovered and your client didn't tell you, or bad stuff oftentimes. So you may have to change your arguments also once you see that, certain points just not getting across to the judge, and, keep making that arguments is not going to benefit you. So it is not as simple as applying a case to a set of facts and then reaching a clear conclusion as if there's a mathematical formula. There isn't. In fact, lawyers constantly disagree with each other what a ruling in the same case means, or whether it can be applied to their case, their instant case. And, while the two sides are arguing about whether that applies, there's no guarantee a court will agree with either side. So it is very hard for a lawyer to answer the question, what is the result going to be? Will I win? Will I lose? How long it will take? How much money I'm spending? I can't answer these questions. To give you another example of shifting situation in a litigation process, even at the very beginning of a case. So so at the very beginning, you may think, okay, somebody brought me to court, and I'm going to court there, for example, in New York or DC. But that's not true. Once a complaint is brought against you, you want to look at it and, you know, you want to analysis whether it's a beneficial venue for you or not. Usually it's not good for the business. And what we do is called removal. We want to remove the case to a federal court, which is more beneficial to business litigation in many ways, which I encourage all my Chinese clients to do and other clients to do if they're a business. But so let's say you want to do that, but then you look at their business contract and says all your disputes arise out of this contract has to be resolved in the, you know, a New York State court, a DC court, then you're out of luck. So be careful when you're drafting your contracts, and you know, when you are stepping into this legal system, you know that the things that you do, every step you take have consequences. And even if there isn't such, you know, provision in the contract preventing you from removing the case in the first place, a plaintiff can still prevent you from doing so by destroying the diversity of citizenship. For example, they can add another plaintiff that shares the same citizenship of your business. And then in that case, you can remove the case to federal court. Remember, you have to have complete diversity on different side of the. So that's another thing. Once they do that, oftentimes, unless you can show there's a fraudulent joinder or misjoinder of the additional party, you can't remove it. You got to stay in that state court where you think you're disadvantaged in the first place. So this is all to show how unpredictable it may be once you get involved in a litigation. You don't even know whether you will be able to get the case into a court where you know you find favorable to your business. But this is all not to say that you can know anything about the chances of winning or losing when being subject to a litigation. Oftentimes, you know, you hire lawyers and they can provide analysis, evaluations of your case on an ongoing basis and let you know, whether your chances of winning or losing on an issue is going up or going down. But when it comes to jury trial, the answer becomes more ambiguous because it really depends on where you are, which court you are in, what kind of jury pool you're looking at. For example, there are certain places in the country, I'm sure you know, that jurors just do not favor the big companies, the big businesses, especially if your big company, big businesses injured some individual and caused a severe, injury, emotional impact in the community. So those are issues that you have no control of. Well, maybe some control, but not the whole control of, or your lawyers, right? So, for example, if you have a product that injured a group of people, and there's relatively clear evidence showing that the injury and the products is linked, the causation was probably there, then you may want to consider early settlement. Your lawyer might advise on that, because before pushing forward to trial, there is considerable amount of money and time that you need to think about, you need to expend if you really want to do this. So there's pros and cons of going to a trial, and you need to weigh every step of the way with your lawyer. You work with your lawyer to weigh that and to figure out what you want to do. Sometimes, a judgment can be surprisingly high because juries do not act rationally all the time. And we've seen that happen all the time. It's not rare. So I'll share with you a story that my colleague shared with me last year when he was representing a group of called EB5. I don't know if you guys are familiar with that term, EB5 investors. So this is a EB5 fraud case that was tried in a Florida state court. My colleague represented a group of Chinese investors, EB5 investors, who was defrauded by companies here that took their investment but did not deliver to them the promised green cards, and so they went to trial. And during jury selection, an African-American woman stood up all of a sudden and gave a whole speech about how she thought of China and Chinese people, and all negative comments. And her story was that she took her daughter to travel to China for holiday and was treated poorly by the locals in that certain city. And she therefore believed that all Chinese were mostly racist and against her and her daughter. And she just wanted to vent in front of all of the, members of the jurors. But right before my colleague was about to start his opening statement. So you can imagine how my colleague felt at that moment. He almost fainted. He didn't sleep all night, and he was about to give the opening statement about how, his client got defrauded. And now there come this woman giving the speech about how bad all Chinese are. So this example just shows you how unpredictable a jury trial can be. And sometimes even if you think you have a good chance of winning on the law and maybe also on the facts, you don't necessarily know what a jury will decide. And sometimes the result might really surprise you. And then there's another point I want to touch upon is the cost of discovery. And it is really high. I don't think the discovery process has anything that we can compare to in terms of litigation in China. So the discovery here is really complex and expensive and invasive. In business litigation during discovery, parties are obligated to produce documents and other information that is relevant to the case, and relevant is a very broad word. Your company representatives may get deposed, your fact witnesses may get deposed, your experts may get deposed, lots of people will get deposed and lots of things will be discovered. And there may be even third-party discovery, which is very common. And nowadays, because all businesses are involved in, not all, but most businesses are involved in technology, electronic management, e-discovery is common in business litigation, especially complex disputes. So the amount of data and documents that a party may be subject to produce is extremely costly and burdensome. I'll give you an example. I've taken deposition in this third-party discovery process in which representatives of some of the largest automakers in the US had to sit down and explain to us. We had like over 10 different lawyers sit because it's a third-party deposition, so both parties are there. We're taking deposition of some of the largest automakers in the US, and they had to explain to us how their business management system worked and how documents and data were housed internally, and even how their pricing departments store their data and documents, how the pricing department worked. So and those manufacturers were not even parties to the case, yet discovery was highly broad and invasive upon their businesses. And that was only because they had relevant information to the case. So as you can imagine, in that process, motion practice was extremely intensive. We had a special master just assigned to manage this third-party discovery in this case. Numerous motions for protective orders were filed, and we filed all over the place. So sometimes even if you are not involved in the case directly, that doesn't mean you're free from concerns, because you might get dragged into a third-party discovery process, and that's something you need to be aware of too here. And so I've talked a lot about the risks. Now, what's my suggestion for dealing with those risks? I would say first is to do your homework, do your due diligence, know this environment that you're stepping into. You have to comply with the rules and regulations. If your patent needs to be registered, your trademark needs to be registered, you have to do it. Don't infringe upon other people's rights, because you will get sued very quickly. So ask your in-house department, what are the rules that I need to follow? What licenses that I need? Can I even, look into importing my products into the US? Do I need to set up a factory in the US? What kind of labor I can use? All these initial steps that you need to think through before you really get yourself involved in the system. Because as I said, every step would have its consequences. And you check with local counsel, the US counsel, about that before you start doing anything, before you start, pouring your products into the US, because you might end up with $1 billion lawsuit. which might destroy your business. And always always, the second suggestion is always be prepared to defend yourself, even if you know that you're doing everything right. As I said, that doesn't mean you don't get involved in litigation. You might get served with a summons and complaint, a subpoena, anything you can think of. People here like to sue. They're very active in the business world, suing each other for strategic reasons or to protect themselves, assert their rights. So if you get served, do not ignore them. Believe me, there are clients who get served even with some kind of notice from the government that they're violating laws, and they just ignore them and wait for 2 weeks to tell us. And that is extremely risky, because the government can shut down your business sometimes if you do that. So just know there is significant consequence if you ignore a notice, a warning from the government, or a complaint, summons, and subpoena. You're obligated to respond to a subpoena. Do not ignore it. It's issued by a court. And then the third is very important. Actually, a lot of businesses, I think Chinese businesses do not realize it. The business here do better here because they're familiar with the system. The Chinese business do not usually have the adequate protection from insurance, business insurance. And those are insurances to cover their risks of certain types of litigation liabilities. There are insurance that may cover, for example, if you are an entity that owns a lot of real property, then you might want to, purchase the adequate business to cover the premise liability. For example, people will sue you every day, everywhere where you own properties. Your tenant will sue you. People that you don't know, you're strangers to, will sue you. So there are other types of insurances that may cover other business liabilities, such as product liability that we talked about. There was a case that my colleagues handled a few years ago in which a Chinese company's product, I will not say what it is because it's confidential, were involved in a accident, and that accident caused multiple deaths. It was a huge case in the States. And then eventually they convinced the insurance company to take the defense of that case. And finally, the insurance company took that defense and defended the client and reached a successful settlement. And that saved millions of out-of-pocket costs for the client. So, and there are other, you may want to, as a foreign company, you may want to check out some of the more exotic types of insurances, such as business interruption insurance, or insurance for labor employment issues, such as forced labor liability insurance. So you may check it out and get yourself protected before you get involved. And then I think another suggestion the professor mentioned is, you may want to consider put in the contract alternative resolution of dispute. Consider, international arbitration, one of your better choices. It'd be faster, it'd be less complicated process than US litigation, and you may be able to choose a different venue, such as, a lot of business like Hong Kong or Singapore these days. You prefer that's your preferred venue, that's perfect. Put it in the contract. Or you can agree with the other party, let's go arbitration instead of suing each other. So those are the things that you need to think about. And lastly, I think I don't need to mention this, but I feel like a lot of the times people forget about it when they are dragged into litigation, is you really need to do your homework when you pick your lawyers, right? The US legal market is huge, and everywhere, especially in the DC, New York area, everywhere you walk on the street, you can shake someone's hand, they may be a lawyer. So you have numerous choices, and the costs vary a lot. So you really need to check out not just the price tag, but also the quality of service that you're getting. A poor judgment that you made in the early decision of who serves as your counsel can directly, significantly impact the result of your case. So you may have saved, say, $500 per hour on the lawyer fee, but then ultimately you may get a judgment of billions of dollars against you, or a discovery sanction against you because the lawyer forgot to, preserve your evidence, etc. So those are the things that I suggest you consider before you step into the complex legal system in the US and conduct your business. And obviously, I wish you all, do your business successfully here. And if you ever need help from, as lawyers, we're here to help. And with my time limitation, I'll end my presentation there. Thank you.
Thank you.
Prevalent struggle with a lot of trials. There are some deadlines of discoveries, emotion, but still thanks for joining us virtually. You can click mouse or use the.
All right, how are we doing today? Good. Okay,
Good.
so what I'm going to talk about is actually taken from a 2-hour presentation that we did for several, actually many companies. So it could be a little bit dense in terms of text. It's also not as visual appealing as Louis' slides, but I will try to pick the most important points. So really quick about myself. My name is Ivan Guo. I'm currently associate at Morgan Lewis. My main practice is called TMT, so Telecom, Media, and Technology. But I also work on national security and trade matters. Previously, educated and born and raised in China. Background is actually EE and computer science, but came to the States to study computer science and actually became a patent lawyer, but then transitioned into my current field, which is a little bit weird, also very broad. But my topic today is really 2 parts. The first part is how to conduct what's so-called a risk-based analysis or due diligence during the merger acquisition process. And secondly, I think many people are familiar with the term, or it's called CFIUS, right? Committee on Foreign Investment in the United States. How you can navigate through the CFIUS and how you navigate through CFIUS and what are the considerations for private sector lawyers, investors to consider. Can they not see the slides?
They can, but there's a block.
Okay. Anyway, I just continue. So really part 1, how to conduct risk-based international compliance or risk analysis. So I think we mentioned a few times about China and Professor Dang, sorry I missed your session, but I'm pretty sure you covered how a business should incorporate before they move to the States. But now a lot of topics are being said on the term national security. And I want to do a quick survey. What's your opinion on national security? What's it really about? I would just cold call on a few people, maybe the lady over there, sorry. Can I ask you? Yeah. So what's your definition or thinking of national security? What does that mean? Just give me a few turns. Okay, yeah, please.
What first comes to my mind is national security get Article 24, and which is a great exception for a country to conduct its police power to regulate the trade and kind of business. And I think it is kind of being abused right now to impact the global trade, especially to build a globalization supply chain. And I believe there should be a multinational convention on how to conduct national security terms. That's what I'm sort about.
Okay, so that's a very good understanding, I guess, from the country side. So assuming you're from China, right? You will think whatever United States is doing in terms of its national security is not going to be beneficial to Chinese national security interests. That's a very valid point. And actually the Chinese government made an argument at the WTO. But right now the WTO is not functioning. So we will just see how United States will maybe submit a protest against that complaint. But in terms of the trade, let's see if I can move my slide. Okay. So in terms of trade, those are the few keywords that you should consider really reviewing a transaction. And I would pick a few because the first of all, anti-corruption. Many of you are familiar with the concept called FCPA. So when a US company or investor is investing in company, they want to understand whether the high-level officials are receiving money from the local government. So that's considered actually whether that's a national security implication, because that could unduly influence a company's operation, right? And the second one is very often now is sanction laws. What sanctions mean is also depends on the local jurisdiction. At least in the United States, there are comprehensive sanction regime. There are also targeted sanction regimes. A comprehensive sanction regime are found normally in certain countries of concern. That actually does not include China. And even Russia is not subject to a comprehensive sanctions, but we have a lot of sanction programs, at least targeting Russia after its act on Ukraine. So that's why when you think about Russia, many people are saying, okay, maybe that's subject to comprehensive sanction regime. Export control, right? That's another very high level topic. At least in the last 2 years, semiconductors, AI to be done, and also quantum computing. Those are the areas of national security concern. Anti-boycott law. I don't know if you have attended the Bureau of Industry and Security, which is a department under the Commerce. They host an annual convention every year. So this year, for the first time, United States BIS stated that anti-boycott laws will be its focus. And then we have some of you also familiar with custom, import, trade remedies, right? During the Trump administration, and tariff are being used as a weapon against Chinese import. So that's some due diligence question we would like to ask, such as whether your products are subject to tariff. If so, how much? How you made a calculation? And the last is actually the traditional concept of national security in the investment world. So that's CFIUS. But I would talk a little bit more about CFIUS because it's a long process. It also has a very deep history, not just in the US, it's actually rooted in some of the Japan law. And I would be malpracticing if I don't mention IP, data privacy, and actually international tax. Those are always the national security concerns. So when we do, as a lawyer, when we do risk-based analysis, we look at a few factors. We normally will evaluate what are the target's business, what's the nature of the business. So if I'm Louis outside counsel and Louis is always investing in United States, I would be asking, hey, what's your client's, the nature of the business, whether it's a semiconductor, right, whether it's a hard tech. And what I mean hard tech is whether the company has products subject to the US export control, whether it's like receiving money from the US government. So the nature of the business is very important. Also, its reputation in the market, right? Whether it's a famous US company, but maybe subject to sanctions, and that's reported in the news. Some of the very reputable companies has its own problem, right? I'm not going to name the companies, but if you look at the name, we shouldn't assume that all US companies are great companies. Also, we shouldn't be saying that all Chinese companies are so-called bad actors. The industry and the countries in which the targets operates, that affect a few things. I think the most important for lawyers is you need to think about the applicable local jurisdiction and laws and regulations. So those are things when you normally ask at the beginning, you say, okay, we understand you are a SaaS company, but at which countries do you have your software? And then that will invite additional follow-up questions, such as data privacy. Third party, right? Third parties are another important question, especially if shipping tangible goods to additional countries. I was recently working on a deal, and the deal involves automation system used in warehouse in the US. And the system is being basically used to ship the products to everywhere in the world. In the freight forwarding world, you have like different components, different suppliers. So we are outside counsel to that company, but what we don't know is where the products are being shipped to, because that's handled by third-party freight forwarders. So due diligence questions were asked essentially to say, are you shipping any products or goods to sanctioned countries? And if so, we will ask additional follow-up questions. And to the extent that needed, we may also need to submit a license application at either the Treasury Department or at the Commerce Department. Existing compliance program is also very important. I think that covered many things. I heard Evelyn said forced labor. So I don't know if you're familiar with forced labor law, but it's a rebuttable presumption. Basically, everything shipped, manufactured, or being used in the ecosystem, if that's coming from the Uyghur region, that's presumably used by forced labor. So you will see many products and goods being detained at the CBP, Customs and Border Detection Protection. So companies are facing issues with that. So you want to make sure that at least on its face, right, the company has some policy governing forced labor. Now, once the due diligence are done, outside counsel go back to the decision makers, and we basically will provide our memo or analysis. But there are a few options for the decision makers, and normally those are okay. All the materials that we discovered or issues discovered, those are not materially adverse to the client. So you can decide to proceed, or maybe the parties are willing to negotiate the purchase price and to maybe account for those risks. There are also times that during the due diligence, you find out that, okay, maybe the company was shipping to a sanctioned entity, or maybe they are like working in some part of the world that's really, again, sanctioned by the US government. So if that's the case, you may want to disclose the violation, or you may also want to obtain a license from the government, and that will cause the delay in closing. So additional bail and suspender will be put in place, and you may want to consider additional transitional period to keep the deal alive. And obviously, if the issues are risky, right? I see many cases that the party just walk away. Again, there are both sides of the transaction. So I'm listing a few considerations for sellers. The next slide will be consideration for the buyers. I just think for the sellers, I'm actually working on this for many of my clients right now, is they are more diligent and they actually are more sophisticated than ever before, especially when they are dealing with foreign investor monies, or they are dealing in the high tech. So I mentioned the self-assessment. Normally, self-assessment is not really needed. It should be company's ongoing compliance program. But the trend now is before they even proceed with the equity round, they were actually asked a lawyer to do a self-assessment as a kind of like internal audit. So essentially, we were assumed that some investors are investing money in the company, and we send them a list of due diligence questions. And by using those questions, we basically do a test, right? We test how the company is doing right now. And we also let the executive team knows what might be the question coming from the investor if and when the fundraising actually starts. There will also be certain things that's going to be missed. There's no way that a company is 100% perfect. I haven't seen any. So if that's the case, then you will say, maybe you will consider internal hotlines. How about the internal investigation committee? How about having another third-party monitor, which is pretty common in the like data-heavy companies. And just having them on the ball will provide you additional data point to mitigate the risk. The second point is for the seller, at least, you want to consider if you want to disclose certain compliance or violations. Evelyn also mentioned the litigation, right? That's part of the equation too. So if there is any pending litigation happening at the moment, and you know for a fact that there will be a very heavy or very important round of finance happening very soon. So maybe you want to consider to disclose that pending litigation or where you can settle that litigation prior to the investment. Of course, you want to always be willing to talk about the materiality of any compliance issues, and then be prepared to, I guess, be flexible whenever talking to the buyer's counsel. Buyer's counsel has a little bit different approach because normally before the transaction happens, they don't really get access to the non-public information. As sophisticated as we can be, even as a buyer's counsel, we don't have access to lots of the information such as the corporate governance, financial structure, whether there are any maybe violation, what are the payroll, right? We don't know the finance number unless they give us a limited disclosure ahead of the investment. So that's the things you need to ask about, and never wait till the last minute to ask. So that's when, like in practice, you will find that at least the first week or second week of the deal, you send them maybe 200 questions, right? Then you send them essentially is what we call the due diligence tracker. You have different tabs, one tab for one questions, labor, finance, legal, sanctions, export control. And for each question, you want to make sure that at least the seller provides you enough information and you put them all in the data room. Actually, I forgot to mention that for the seller's counsel, we also create a data room, but it's not going to be a clean room because we don't normally send everything to the buyer. There are some documents that we do not want to disclose. I think I mentioned a few things already, but obviously the important part is always reps and warranty, right? Those will be the clauses. Consider buying insurance to cover the transaction period. And if needed, always try to indemnify the other parties. That includes third parties as well as the buyer. Also make sure that the buyers, you prepare for the buyers a list of questions for them to ask, because not all the questions are legal questions. I guess just be mindful. And of course, the last point is if a target is a public company, there are always the SEC disclosure obligations, and there will be essentially additional data point that you should find. So that's really what we normally consider during the due diligence process. I think you can see, at least during my practice, which is not long, by the way, but there is a shift in focus. I think back in 2018 or 2019, there wasn't much focus being put on, I guess, export control. There are also not a lot of focus being put on the level of scrutiny against the Chinese company, because I don't know if you're following the term, it's called foreign entities of concern. There's also another accompanying term called foreign countries of concern. So unfortunately, at least for the US government, China wasn't on the list until pretty recently. But now when the US government or even the Congress is talking about China, it's considered not just a competitor, but really a country of concern. So that's what triggered all those questions. And this is just a really, really short list. The actual slide that we use has more questions. Do you have a question? Okay, sorry. Yeah. So now the part we'll be talking about CFIUS. Really briefly on the background, this is a timeline about the foreign direct investment. So when we say CFIUS, this is just a committee used by the US government. So a few important timeline is we need to remember United States is actually not the first country that enacted foreign direct investment regime. Japan was the first one. It actually has a very robust mechanism, including notification, licensing regime. But following that, in 1975, there was an executive order that first time established CFIUS as an ad hoc committee, but it does not have any implementing rules, meaning CFIUS, although it existed back then, it doesn't really do anything. It does not review transaction if needed to. However, things start to change since 1988. An Jackson-Florio amendment was introduced, and that amended the Defense Production Act. The background of that amendment is actually very interesting. During that period, Japanese automakers are minting cars, right? They are essentially dumping all cars, and those cars are made by Toyota, Honda. So the United States traditionally, they want to protect their own country and also their own automotive industry. So they made this amendment essentially, and there were some following amendments made to make the CFIUS a more active actor to review potential concerns to its national security. So another important amendment was made in 2018 that really consolidated all the random rules and also the jurisdiction of CFIUS. It's the one in the middle, the Foreign Investment Risk Review Modernization Act of 2018, which is really mouthful term, but I just call it FIRMA. Under FIRMA, the CFIUS, they have its own jurisdiction. They also has very detailed rules on what investment they need to review. And the actual implementing rule was really put into place during 2021. That's why around that time, CFIUS become a hot term. And if you're trying to like get to a job or you are working in the in-house sector, CFIUS is always a term that people keeps asking about and talks about. What had changed during that period, essentially from 1975 to present? Essentially, critical and emerging technologies are being defined and used in lots of the determinations. Commerce tried to define the term. So it has a long list of the term, and the United States this year updated its 2024 list of critical and emerging tech. However, the list is only for advisory purposes. It does not have any binding effect. So let's assume that AI, which is one of the critical and emerging tech, AI is being mentioned, but is AI really a covered transaction, which I will talk about under CFIUS? The answer is, again, sorry, it depends. But most likely it's not a controlled transaction, but then it's also a fact-based inquiry. Supply chain vulnerability is also being reviewed. So CHIPS Act that we mentioned, Greenfield Energy, battery, right? So those are the supply chain vulnerabilities. So you will see companies trying to reshore their supply chain by either move to Mexico or sometimes they move to another country in Southeast Asia for manufacturing capability. There are new national security concerns, healthcare, telecommunication, and new financial considerations. Passive investors, whether they can exert control or influence over a US company, right? That's something being really asked by CFIUS these days. Last but not least are geopolitical factors. I think some of you may, again, have heard this, the committee called House Select Committee on a Strategic Competition with Chinese Communist Party. Its short name is House Select Committee on CCP. That committee has issued many subpoena letters to companies, even benign companies, asking them about their relationship with the Chinese company. It's a very hawkish subcommittee on the Hill, but it caused tremendous damages to the entire industry. And they also even affected some of the investment community because actually in the investment world, most of the investors are still China friendly, but that's not the same view shared by the lawmakers on the Hill. Some of the truths that I want to say about Chinese investment in the US is that Chinese investment is still very, very active. You will see from the CFIUS, they published a report in 2022. You see less Chinese investment voluntarily submitted the notice. But the fact is, if you look at other countries, including Singapore, Mexico, the filing numbers are going up. What does that suggest to us, right? Take a few guesses, but most likely is Chinese companies are trying to find a different place to incorporate their business or to make themselves look like a non-Chinese company. So that's a guess. Unfortunately, the 2022 CFIUS report does not provide any additional data points in that regard. And there are also new participation by new players, so there will be policy concern. It's actually more important than ever for the policy player to have a say during the entire process. I think I'm going to jump this slide because the last bullet point is I just mentioned a few executive orders that we should really remember, because everything could be as stable as it is right now, but depends on outcome of the election. There will be executive order issued, and we've seen this very often. There were 80 executive orders issued by different presidents, and there are still 40 executive orders still claiming a national emergency situation. Here are the member of the CFIUS. The left side is the permanent member, so it's chaired by the Treasury, and on the right side are the members based on its jurisdiction of interest. Department of Agriculture, for example, normally is not a permanent member, but why it's there? Because there's also worry about foreign nationals acquiring an agricultural land that's too close to a military base. Right? So we all have heard the Florida bill attempting to prevent foreign nationals to acquire land. There are other states in the US trying to do similar things. So that's why Department of Agriculture is also a member of the committee. So this slide is really, it's really short, it's only 3 bullet points, but you will be amazed to see how complicated the analysis actually are. But just in even like 10 seconds, what the CFIUS analysis or inquiry is you ask 3 questions. One is whether you have a foreign investor. Second is, do you have a US business? And when I say US business, I mean whether it's a TID business. T stands for critical technology, I stands for critical infrastructure, D stands for sensitive personal data. And last one is always the national security equity. And here is the analysis. You can take a picture or try to take a deeper understanding of it, but all the questions are asked, and we're trying to understand whether we have a covered transaction. And if there is a covered transaction, if we also want to ask what are the possible additional scenarios that we need to consider in order to make sure, do we need to even submit a voluntary filing, even assuming this is not a covered transaction. And I said voluntary filing because under CFIUS, after the review, there are 2 types of transactions. One is a voluntary, one is a transaction not subject to the control. So if that's the case, you can still submit a voluntary filing. And there are companies doing that for strategic advantage. And those are the investors normally from European countries. They just want to submit it because once you submit the filing and CFIUS says, okay, no covered transaction, then you get into this safe harbor, right? They cannot come back and say, okay, you did not submit the filing, so that we have to either issue a fine or divest your investment. There are always time for the mandatory filing. So if I'm investing in a semiconductor business, it's most likely to be a mandatory filings. So that's why there's always these factors during the equation. And obviously each deal depends on different factors. How you structure a deal. We seen, actually I have seen many PE or VC in China. They're trying to establish a US dollar and a renminbi fund. But the formation is not done in China. They're trying to do the formation in other friendlier country. There's always the timing of the rights. Like, for example, you are just investing as a private investor. You want to just maybe have some passive right, but you may want to install the board observer or install a board of director at a certain point if the product reaches a certain time zone or milestone. So that's why you can also exert influence and control of the business decision of your target or portfolio company. So.
Sorry, I have a question.
Yeah.
So, because.
Do you want me to go back to the previous slide?
Yeah.
Okay.
So the controlled transaction may be subject to voluntary or mandatory filings. So if it's voluntary in some transactions, then what are the main benefits of filing? And if it's mandatory, then what is the punishment if failed to comply with CFIUS?
So I will answer the mandatory filing first. If it's a mandatory filing, CFIUS can issue the penalty. Right now it's $340,000 or up to the value of the transaction. So let's say if you made a deal that's a $1 billion deal, CFIUS can normally use the transaction value and ask you to divest the investment. So it's not a fine, it's just CFIUS asking you to divest the investment. So this creates uncertainties during the deal, right? Because you know that they could maybe issue the penalty up to $340,000, but they can also ask as you as an investor to really divest the investment. So that's a mandatory filing. For the voluntary filing, really there are pros and cons. I think many of the, at least in my experience, many Chinese companies are trying to evade CFIUS. And I think that's a good business decision to a certain extent. But there are also downside because by submitting a voluntary CFIUS filing, you obtain a safe harbor rule. So you can, if you do a voluntary filing and then in the future CFIUS through its own intelligence network, realize that you as a Chinese company bought 50% of ownership interest in a US TID business, they may come back to you and then it's not going to be a good public relation image for the company. There will also be fines associated with that. But if you do the voluntary filing, you will be considered as a known entity, right? Yeah, because they will basically know the background of the transaction. They will also have a better understanding of you as an investor. So many companies from Singapore, they're actually doing a voluntary filing. If you look at last year's filing, the stats, I think Singapore used to be 10 voluntary filing in a year. I think in 2022, it was up to 60 filing. And now Singapore investor is actually the #1 voluntary filing. So that kind of explains why they are doing this, because they want to be known by the US government and try to at least create a profile by the US intelligence committee. But obviously, at the end of the day, it's always a business decision because we can always say, you have a mandatory filing requirement. And I've seen this, the client just said, no, we don't want to file. So that's the end of the story. But I think as a lawyer, we can then try to create some contractual provision language to basically tone down or maybe have some better contractual rep and warranty language, or we just will indemnify all future potential fine. So that's something you can do as a lawyer too.
I also have a question.
Yeah.
So, you said the CFIUS is conducted by a committee, right?
Yeah.
So once they start to review the company, do they have a specific rule to go over, or is pretty subjective by the committee?
It's not a subjective rule. They have a very robust 800 as a CFR part 800 rule. So if you look at it, it's actually pretty dense. They have a definition for it's public, yeah. Actually, I will say this. I think many of you are law students. For the United States, at least, if you think about the rule, the first place you should go is a Code of Federal Code. So you go there as a CFR. So you'll go there, you can find many regulations, you can find more about the definition. So that's why I have these slides here. But if you try to understand, for example, what is a US business, right? You go to the CFR, take a look at the US business definition, and then you can actually learn a lot from there. So, but in terms of the actual judgment, I would say there is a big part that's being played by the policy players. So I would just give you an example. If you are trying to buy a semiconductor company in the US, the company has a 5 nanometer production node. There's no way you can get through the CFIUS, period. Right? Even if the company is owned by a Chinese investor, very clear, no affiliation with the government, right now there's no way you can get through a deal. So those are the kind of
So
the
there's some part of subjective part
Yes.
within it.
right. Because at the end of the day, I think I asked this question, what is national security? For the US government, it has own thinking about national security. It's also evolving, right? When I started my practice, national security is very simple. It's limited to telecommunication, right? The network equipment. But now you ask me what is national security? It's almost everything like solar panel, forced labor. The US government is also concerned about China's military civil fusion, green technology, battery, for example, right? The Treasury Department, also the IRS, they have a 30D tax credits for renewable energy vehicle. But now they also have other rules to say what companies cannot get a tax credit if it's considered as a foreign entity of concern. So I think we are living a very interesting time. And really the situation is fluid as a law student or some of your clients or practitioners, you should try to make sure that your skill sets are comprehensive. I think the last slide basically is a summary of what I described so far. I think I did not mention cybersecurity and access to data, but my advice on that is take a look at US. In the US, there is a very nice research institute. It's an independent government entity. It's called Congressional Research Service. They just published a report on TikTok. And in that report, they listed about, I think around 100 frequently asked questions about TikTok. So take a look at that and you can have a better understanding of what are the national security concerns in relation to cybersecurity and data. So I think I will stop here. I don't know what time it is now. Do we have time for questions?
Yes, we can.
Okay.
Answer questions now.
Yeah.
If participants have. Feel free to raise your hand. Have question.
Yes, I have a question for Louis and I have a question for Ivan. So for Louis is, you mentioned that China as a supply chain is very important for business around the United States and around the world. So we worry that as an entrepreneur, we worry that because the tension between the US and China is increasing, and we worry that the US may want to replace certain Chinese components, and China may also issue regulation in the future that restrict is whatever technology or its components or its product to be shipped to the United States as of certain purpose, like maybe Chinese government don't want their components to be used on like NASA's rockets or these US national securities project. We worry about like these supply chain issue, and we will consider that moving your supply chain to more friendlier, like more less restrict countries like India or Vietnam or other countries. And for Ivan, is like you mentioned that there's a CFIUS review process, and it's based on law, although there are subject to human manipulation, like political factors, but there are laws that we can find it in CFR. So if that's the case, like if CFIUS decides or come to a negative result, will you have the chance to like appeal to court to let the courts address that issue? Thank you.
All right, I guess I'll go first.
Yeah.
Okay, I think on the topic of supply chains, I think it's the simple place to start is always kind of with the law. I think we do live in a country of law, and I think it's yes, it's hard to predict the future, but I think there are just kind of good common sense practice on things that it's probably gonna be, closer to national security and more of a topic kind of for the debates kind of down the roads, right? So I think, we went over three sectors, right? With the space, we talked about kind of automations, AIs, right? And we talked about kind of green energies, right? You can argue kind of, on the surface, all three of these are pretty sensitive kind of, sectors, kind of to be kind of dealing with Chinese supply chain, and I think in the area of the space, I think that's already a clear cut. That's not an option, right? And I think that's not an option now. It's not going to be an option in the futures. AI and the very same thing, right? But when you're talking about, hey, I'm building a consumer electronics product, okay, that's kind of in these macro specs, that is, hey, these are not like brand new kind of, I would say hard tech, but its applications, integration is, kind of where the meat and the technology is. And I think for this type of theses, I think it makes sense to look to China because it's already very mature, it already exists. It's there whether you like it or not. I mean, they're already supplying the majority of the world's electronics. But I think with a more, kind of to your second point of your questions, right? I think with a more dynamic world, I think it forces everybody to rethink their supply chain strategies. I think in the past, it may be very simple. Okay, everything we just push it to China and then be done with that. Now, these days, I think China is a great option, and often a great option to start, but it's definitely not the only options. And I think you just need to kind of constantly monitor kind of the latest, kind of ruling, right? Can we go with the law, right? And then kind of adapt. And I think thankfully, I think there are a lot more options kind of beyond China as well. Although I do think from a capability and cost and delivery wise, I think there's still some years kind of gap kind of between these new options. But I think it is a trend that everybody's going towards. So it's rather than a very China-centric focused supply chain kind of thesis in the past, I think now it's going to becoming more diverse. There will be new opportunities associated with that.
Okay, thank you. Yeah, I think I want to add to that. It's just another factor that normally is discussed, at least during the transaction, is like, what are your end customers? Right? Are you trying to manufacture products for the United States, or are you trying to manufacture product just for China? So it depends on where the customers are. There are like logistic concerns. There are also other like local tariffs. There will also be in certain jurisdiction export control questions. So you may have a very complicated situation, but I think definitely the trend is now like moving at least or diversify the supply chain based in China. And there are many countries being discussed, but I just think this is just a trend we're going toward that direction. But to your question on the CFIUS review and the decision is not subject to the appeal. So you can appeal to the district court, right? You can challenge the appeal. So there are two different appeals. One is appeal to the CFIUS on its final determination. But CFIUS, the rules does not provide such a procedure. So the only option for the company normally is to challenge at a court. But we don't really see that because there's a court, it's a Supreme Court case, Chevron deference. Essentially in the national security area, most likely the court is going to give deference. It's almost, I would say, maximum deference to the US government agencies. And if you look at the CFIUS law, the law is really clear on what the agency can do. It's reviewing from the national security angle. And if you look at a member of the CFIUS, who they are, Treasury, Department of Defense, policies, there's also state government, right? So, the State Department. So can you say, put a prima facie case or challenge, say, CFIUS is not entitled to make national security determination? The chances are you can file a complaint, but it will be dismissed really quickly. And also another consideration, parties do not want to review their transaction details. So if you're talking about a court challenge, there are chances that both parties' reputation will be damaged. But I cannot get why you're asking this question because nowadays there are so many companies being added to the entity list or 1260H list, right? And we see news reports that once the company are being added to the list, a lot of them are trying to file legal challenges. Some were successful, but if you really look at each determining factors, you will see, I think, different outcomes, and the courts will also have a different opinion.
Thank you. In this case, I think with somebody concerned that CFIUS is too powerful, they can use, because like what you said, even the court are like the government, right?
Well, CFIUS is not powerful because you are only subject to the mandatory filing if the transaction meets the definition. First, you have to have a foreign investor, right? The second one is you need to have a TID business. That's laid out by the law. But what you are saying is you are trying to say the law itself is too powerful, not the CFIUS. But in order to change the law, you have to make certain constitutional challenges. And so far,
if I file against CFIUS, you said the court is in favor of the government, even though the rule is like we have some argue on the rule. So
Can I add, I think two comments I want to make here. First is that there are huge sectors of the economy where there's no question that there's no national security interest, okay? So that there's lots of supply chains that will keep coming to the United States. So to focus on the CFIUS issues, very important set of issues, right? High technology issues, maybe where people want to be, but it's not the whole economy. So that's one thing. But second is that, and I think Ivan mentioned it, he mentioned it both ways, but I mean, yes, we have a code of federal regulation and they're very specific in what's provided, but ultimately, this is a discretionary decision that CFIUS makes on national security grounds. And national security, I mean, I should ask each of you to define national security. And then as we would apply it to particular facts, you say, well, maybe there's an issue, right? I mean, you can see that it continues to, sort of evolve and expand. What we all worry about is that everyone thinks that everything's national security, right? In which case CFIUS is all powerful. We're not at that point now. I don't think we're going to get there, but it's something to continue to be concerned about, I think.
Just one thing came to my mind is that according to CFIUS 2022 reports, you mentioned that Singapore companies' numbers are growing in those filings. But I think because according to what Professor Dong told us, is like when you are doing due diligence process, you have to look for beneficiary ownership in this company. And if you look into those beneficiary ownership, then you should find that those investors are Chinese or Chinese companies. Then, so why CFIUS won't block those filings in this place?
Yeah, just to clarify, CFIUS, when we talk about foreign nationals, is talking about foreign national governments. So you can still have a Chinese company, that's totally fine. You can also have a beneficial owner of Chinese, that's also fine. What they don't want is they don't want someone who is backed by Chinese government, for example. But on the other side, right, that's the question number one that was shown on the screen. The second one is is it a TID business? So that's a separate inquiry. As long as it's a TID business, you always make sure that, and just, this is kind of a longer conversation, but I would just start with T. T again stands for critical technology. How you make the determination. And from the CFIUS side at least, they want to make sure that foreign nationals does not have access, either by direct access or indirect financial interest to control the US technologies. So they actually use export control determination in order to determine whether foreign nationals will have access. But again, that doesn't go to the beneficial ownership question, because that's still question number one. But the second one is always a separate fact-based inquiry. What are the technologies? Is your technology being used in critical infrastructure? They have a list of the critical infrastructure and how many sensitive personal data the company is collecting. So again, just want to clarify that.
And I think one of the real challenges with China is in some ways the role of the Chinese Communist Party, right? And when you look at certainly the larger companies, at least as I understand it, there are mandatory requirements in the governance structure that the Chinese Communist Party have representation, membership, certain controls, informational controls and the like. And what that means, the Communist Chinese Party to the Chinese government, I admit I don't understand, I don't fully understand, but I think that's where an intense level of concern is. So when you think of Singapore, maybe as an example, and even if Singapore companies were owned entirely by Chinese or Chinese ancestry, it's not with the government involvement, right? So in some ways, less reason to be concerned.
Yes, I think I would like to ask as a law student, so to what extent could we as as a law student to participate in like high-tech industry? Do we need to be like a professional, or we just know certain things that we can participate in certain business? I'm just curious about that.
You still want to take that one?
What do you mean by?
I'm not sure I understood the question either. Could you repeat it?
Because we as law students does not know a lot about how high technology works. So to participate in this kind of business, from a law perspective, how much knowledge should we get to like understand what is going on?
And you two are bad examples because we got a mechanical engineer and a computer engineer, right? So if they don't have that background, can they participate?
I think that's continued topic of CFIUS, right? I think in the tech world, I honestly think this is booming time for all lawyers, okay? Like this continued evolvement of CFIUS and, kind of foreign controls. I think it's a hot topic now in the Valley, and I think in all of investment worlds. I think because everyone knows that the world's becoming more dynamic and becoming more blocked, right? Everyone knows, yes, it may not be a problem today, but it may be a problem tomorrow, right? So whether you talk to investors or you talk to new startups, even though there's maybe no mandatory law that's in place, across kind of all sectors, I think people are starting to self-enforce, that disciplines. So in all your due diligence, where you're talking startups, VC people, the topic of, foreign investors, or really like, the people are becoming more and more cognizant kind of this topic. And I think it's as complicated as I think Ivan has shown, right? And I think people what's your first national, well, let's go talk to the lawyers and let's figure out, kind of what our actual risk is associated with this particular investments, with this particular build-up. So I think from that perspective, I think the technology, I think, yes, I mean, it is essential to know, okay, what you're talking about, right? So some knowledge of the technology, I think is critical, but I think it's the overall trend. I think in this sector, I think it's a booming opportunity.
Yeah, I agree. I think also as a law student, it depends on the practice you are trying to get into. I think Evelyn is also online. She must have dealt with high technology cases, right? Even as a litigator with no technical background, there's no way that you have never handled tech cases. For my case, I would say the main advantage is the client really want me to talk to their engineer. And I can do that because I know their language. There's only one thing I don't really do, and I still don't understand, is we have an investor, he invests in quantum computing technology. So my partner put me on a call, and the general counsel also want me to on the call because he knows, he thought I know quantum computing, but I don't. But still, I think on the face, it helps you to build your brand image, because as a technical lawyer or as a lawyer who knows some technology will help your career. Also within the law firm, it's normally, especially in due diligence stage or during merger acquisition, you work with a big team. So you may have lawyers with very deep technology background on the team, but if you're just a merger acquisition lawyer, you can always dive in and listen to the conversation. I'm kind of jealous because I cannot do that. I have to speak during the call, but you can always see maybe 2 merger acquisition attorneys are on the call and they're actually listening to the conversation, and their skill set is also evolving. So I always say don't worry too much. It's more important that you pick the platform, and I think at an early stage, early career, a broader practice area that can at least have this high-tech piece. I think that's more important.
Okay, sorry for interruption. And we are a bit run out of time, so I think that's the end of our panel. Not the end, we have lunch and also networking session. So really want to thank all the panelists, and thanks for support from CTBL and GCLS. Yeah, thank you, everyone. May I ask all of you to come here, then we can take a picture and then we can, yeah, just show in our now the social platform.
Get out. Oh, my. Need to sort of expand.
什么东西啊？
Okay.
Sorry, guys, we only have 30 minutes left. so-
Can't eat until you come up to the photo, so everybody come up to the photo, right? You gotta use incentives.
There's enough space. We want me to. That's right, they'll see there's enough space. Okay, sure, don't worry. Oh.
Okay? Now there's more space. There are sometimes easy solutions. Yeah. It's fine. It'll be enough. Come on up. What's he saying here? Yeah, everybody, no, no. Well, I'll be over here. Come here. Well, I was doing it. No, no, it's easy. Come here. You can't. Well, you can't go way over here. can you? Here, why don't we move up a little bit? Move up a little bit. Everybody come back behind too. I mean, we need you over here, not over there.
Yeah.
Over here. Keep coming in. Come closer, closer. Okay.
All right, is this good?
Maybe you need a panorama view.
You all fit, so it's good.
Oh, perfect.
3, 2, 1.
Bees.
You go, please.
Bees.
Okay, 3, 2, 1. Good. Thank you.
And now we have lunch?
Yeah.
This is like the best Chinese food in town, is that right?
Maybe, I think
Okay. No, no, no.
I heard of it.
Do you know the restaurant? Which restaurant it is?
It's called, I don't know English name, Chinese name Star Hong Show, which means it's a